What's up, everybody? Welcome back to another episode of the Lawyer You Know podcast. And today we're going to be jumping into the Take Care of Maya case, where there is a ton of unfortunate infighting between the plaintiff's lawyers, things you really wouldn't believe, things I've never seen before in a case, things that are almost too wild to make up. And when we read through some of these documents, I can't believe what I am reading and what I'm seeing between two lawyers that did such a good job in a case, got such a huge verdict. We're celebrating together. Everything seemed like it was great. And we're going to talk about kind of what we think the problems are, what the downfall was, who is at the end of the day really going to get the short end of the stick because of all of this. And I'm really excited about the guest this week. It's one you guys have requested a ton. And this is the perfect case to bring him on because he followed it at length every second of the trial, breaking it down, was into the weeds on it. And he doesn't really need an introduction, but we're going to put all of his links to all of his social media, YouTube, things like that. Real lawyer, real practicing lawyer, which I always love to bring on because the people that are in the trenches understand what's going on and are at the forefront of things that are changing potentially, what's happening in the courtroom, what's happening in the law. And we have Rob from Law and Lumber himself here on the show. What's up, Rob?
Hey, Peter, how's it going?
Well, it's going. It's freezing here. I was just talking about it on the video I did earlier today. It's like snowing in Florida. And I'm just sitting here freezing myself because my wife does not believe in the heat. She thinks it makes the kids sick. So instead, I just get to freeze. I've got a blanket on, a sweatshirt on. It's even colder where you are, though. So I'm just feeling like a baby.
Oh yeah. There's school has been. Has it ever been so cold where school has been delayed by 2 hours just because it's that cold?
Not snow, just cold.
Oh yeah,
I didn't know
cold.
that was a thing.
Just cold.
No,
It
I
is here.
did not know that was a thing. That is absolutely wild. So you covered Maya the whole trial, even some stuff that happened after the trial. The lawyering in it between the two sides was hostile at times, tons of sanction motions, but at the end of the day, Maya's team won. And just for anybody that doesn't know about this case, there was a Netflix documentary called Take Care of Maya about a huge scandal that happened at a premier hospital in my neck of the woods, Johns Hopkins All Children's Hospital, where there was allegations of abuse and neglect. And her mother took her own life because they separated them from each other. And a jury found for Maya and her family and even put the cause of the mother's death on Johns Hopkins All Children's Hospital to the tune of punitive damages included, by the way, to punish Johns Hopkins, $200+ million, one of the biggest verdicts of all time, basically, in Florida for a non-class action lawsuit. And she had two lawyers mainly that tried the case, Greg Anderson and Nick Whitney. Nick Whitney was a younger lawyer. Greg Anderson was the older lawyer, the founding a partner of the law firm, did most of the trial, but everything was great at the end. Hugs, kisses, crying, happy, celebrating justice from their perspective. And then the very dirty A word happened, appeal, that creates so many issues in cases where the clients win $200 million. The judge said you have to pay it to us, but then you don't because there's an appeal, there's a process, it's fair, it's how the system is set up. But sometimes it can be used as a delay and creates major issues on one side that's got tons of costs out there, that's owed money for fees. The client wants their money because they think a jury said I get it. Why don't I get my money? And that has some stuff has stemmed from that. And the first thing that we've already broken down in a prior video that anybody can go check out on my channel, the Take Care of Maya playlist, was when Nick Whitney withdrew from the case, left Anderson's law firm. He says because Anderson wouldn't give him a proper accounting of where the money went. And if you're asking what money, Peter, you just said they didn't pay. Well, it sounds like there was some kind of advance from a funding company for maybe some costs, some fees, some money to Maya. And when money gets involved, problems start popping up. What was your first thought, Rob, when you heard Nick Whitney, after seeing the celebration, having them on your show, I believe, talking to them about, how great this was, how this was justice, everything was good, vibes were high. And then when you see Whitney is withdrawing and leaving the firm, what were kind of your first thoughts about how this team was so successful and now look what's happening?
I mean, part of it was just an initial discomfort. Yeah, I've met both of these individuals. I've broken bread with them at the same table before. And you have this added complication when fees become the subject of controversy, right? 99% of the cases that we end up seeing in a courtroom, even when it gets to court. So first of all, you have 90% of cases settle before you get to trial, right? 10% that do go to trial. 99% of those cases, you're not seeing any disputes over the fees. That doesn't come up. This seemed to be a bit of a one-off, and you're looking at it, and once fees become subject to controversy, and usually you're talking about a fee dispute between the defense and the plaintiffs, but very rarely are you getting this back and forth over how fees get allocated between the two lead counsel. Then you kind of see a little bit of a, it's the best way of phrasing it, like a yellow flashing light. You just kind of go caution, caution, caution. We are about to get into a place that's very dangerous and fraught for both parties involved. So immediately felt uncomfortable and a little bit curious, and then concerned for what would happen with the case because it was actively on appeal. So that was my initial impression.
And there were a million issues that could be potential appellate issues, right? This is far from a slam dunk. It was a very different case.
Oh, yeah.
But the easiest way to handle this really is you have all this taken care of beforehand. Whether your partner's in a law firm, whether it's an associate and a partner, junior associate, senior associate, whatever it is, you got to determine how lawyers get paid, right? And if it's sole discretion of the managing partner, that's how some firms work, then you take what you get as the lawyer working the case. But certain law firms have salary. You get paid a salary. Whatever you do, you get a salary. You don't get anything on top of it. Or you get something on top if you generate the case. You bring in the case. They call and say, hey, I want to hire Rob. Or you can get paid if it's my case. Hey, I want to call Peter. I want to hire Peter, but I'm like, hey, Rob, come work on this case with me, and I'll give you X% of the fee for your help working on the case with me. So there are different ways to set out how lawyers get paid on cases, and it should be pretty black and white if it's all in writing. Now, if you're not as organized and you don't have everything set up ahead of time, and then something like this happens, and then the lawyer's like, well, hold on a second. I feel like I'm entitled to X. And he said, well, I feel like you're entitled to Y. Then that can create problems. It seems like maybe there was some gray area in what Nick Whitney felt like he should get paid and what Greg Anderson felt like he should get paid based on this case. And then it adds a layer of complication where they weren't just paid whatever their fee was on the $200 million because the defense didn't pay it. So if there was some partial advance, how do you distribute the partial advance of fees? Is that the same way as you would have if it's a full fee? All sorts of issues, especially if Anderson put out the costs. Does he get to take the costs off top? Just, it gets dirty real quick. And dirty is not the right word. It gets complicated real quick if you have situations like this.
Yeah, and it gets even more complicated when you have a case like this, which had exorbitant costs, right? So every bit of litigation, all litigation, when you have to call experts, when you have to have multiple depositions, becomes remarkably costly. Keep in mind, this particular litigation got put on pause while a certain matter is being appealed upwards. So you had the cost of multiple depositions, several experts, ongoing court transcription that had to be paid for, an interlocutory appeal that had to be ruled on and then sent back down, a time that this case was kind of pending without review for 2 years. And all of those costs keep mounting. So that's another added wrinkle to this. And finally, the other added wrinkle was one that you mentioned earlier, which is something that a lot of people don't know is out there. And it's these litigation funding entities, the places that will advance a certain amount of money to fund litigation ongoing. And you're in personal injury where you see a lot more of this stuff. I don't see it a lot in my practice of domestic relations litigation. So maybe you're better capable of explaining how those litigation funding firms work.
Yeah, I mean, and again, we went into detail on this on the prior video that I did, but they basically, my partner calls it like legal extortion, basically. But they give you a certain amount of money and they take a huge percentage on the back end and interest. So it's like they give you $1,000 now and you got to pay them $2,500 at the end of the case. Not all of them are quite that bad, but it can really be a situation where you borrow money and you have to pay huge amounts on top back. So in this case, if they were to give $1 million and you got to give $1.8 million back at the end, you can see how that creates some stress, creates some issues. But if you need the money up front and you can't afford whatever the costs are, or you can't float the fee anymore, you've been working on this case for 7 years, I want part of my fee, you get it that way. We have never, ever, ever advanced costs or fees ever in my firm's history. The only thing that's ever been advanced, if a client needs to pay rent or something like that, we advise against it. But sometimes it becomes an issue that a client really has to do, and we understand. And these companies come in place where you can't get a loan from a bank or something like that, and they do get some kind of small loan to pay rent for 1 month, something like that. But when you really get into the huge numbers, it can create conflicts between lawyers and clients as well, as we're going to talk about when we get to some of these documents.
And that was my other question is, when I've seen them come up, usually they're related to costs of litigation. I don't know that and one of the costs of litigation obviously is payment of staff and it's oftentimes associate attorneys that are like the salaried employees. I don't know that I've ever seen funding companies paying attorneys fees, advancing attorneys fees. See, that just seems kind of, well, maybe I'm naive in this regard. I just
So
don't run into it a lot.
I haven't seen a lot of it, but I'll tell you right now, very recently, this past year, we took a case over from another firm who had done this on a partial settlement. And we basically told the funding company, we're not paying you back for that. That's not my client's problem. They fired that lawyer. You guys advanced them the fee. And they were just like, they fought with us a little bit, but eventually
Oh
they were
yeah,
like,
because it
okay.
would be with the fee.
Yeah,
Oh,
we're like, too bad. That sucks. Maybe next time don't do that. Because
because costs would be treated differently because the cost would
oh
be a
yeah,
cost of the litigation
for sure.
itself.
Yeah, yeah, yeah. And our client would owe that. Yeah. Yeah, it just is not a great setup, and we're going to get into some of the documents now, and it's important to understand kind of where we came from. That's why I wanted to give that background. Uh, Anderson was not happy about the way Whitney withdrew. He calls it loudly in these documents because he kind of airs out some of their dirty laundry. And this is the document that Anderson like kind of gets back at Nick Whitney. Oh wait, I think I need to mention one more thing. So it's also important to note that Whitney withdrew. Anderson files a motion saying, yeah, good, you can leave. Maya's okay with it. And her family, they sign off. They're in lockstep with Anderson, so it seems at the time. And then now these motions flood and give us some new information. This is a notice of filing revised response to motion for substitution of counsel because Nick Whitney filed a motion to substitute in now, and Maya and her family now have chosen Nick Whitney to be their lawyer with another lawyer. So much to get to. But now they're not talking to Greg Anderson and not with Greg Anderson and his firm anymore. So basically, he's telling us that in this motion, they've got a motion to relinquish jurisdiction and remand to the trial court attached as Exhibit A. Basically, we're just going to skip that one. I'm going to summarize the fact that he wants this to go back to Judge Carroll, the trial court, because he thinks the trial court's in the best position to make this decision on what we're going to do with all these lawyer issues, who's going to substitute what fees are being protected, how are we going to deal with this judge. And Judge Carroll has dealt with the trial kind of throughout the case, but it's technically on appeal now. So he needs him to grab that back, which there's no guarantee he will. And then Exhibit B, which is the motion for substitution of counsel, or the response to the motion for substitution of counsel, which is where we really get into the meat of what we want to talk about.
Yep.
Go ahead.
Oh no, I was just going to clarify that some people might have the question of why would you ask it to be remanded? Because when a matter gets appealed up to the appellate court, jurisdiction by the trial court is lost. It is no longer within the body of the trial court to make findings, rulings, or anything else. The entire matter is technically speaking up on appeal. Now the appellate court can basically say this is a fact-finding issue and we are not in an appropriate position to do that, and we feel that you need to decide this before we can hear our argument or the appeal on these issues, which this might be a case, but then they can send it back for limited factual findings by the trial court.
Yes, great point. And in his letter, in the first motion that he filed, he attaches this email. Okay. And when I read this email, it just kind of gives you the vibe of what's happening here and how you have to be really careful, almost like some people are saying the Baldoni and Lively lawsuit, everybody's going to come out looking worse at the end of it. When I read this email and saw that it was attached to a motion, that was kind of my gut reaction is this is not going to be good. So this is a letter or an email from Jennifer Anderson, who is Greg's law partner and wife, right?
Mm-hmm.
Okay.
Correct.
So it says, Nick, I was on the call with Jill. After the rather unexpected and aggressive text you sent, we assumed you were quitting. We never told Jill you were fired. Greg only instructed her to turn off computer access until we could figure out your mindset. She made an incorrect assumption without any authority from any partner. When you relayed you weren't quitting, the very next day, Greg instructed your computer to be turned back on, which Marty did. You have not been terminated. Any action of leaving the firm is of your own accord. It is disappointing that any of this is happening. So this is in response to, in Whitney's loud withdrawal, he said that they terminated him because he wanted an accounting. And in these types of situations, if you have an employment contract, whether you're terminated or whether you quit can make a difference. They could have an agreement. And I'll say this as well. Some law firms have an agreement where if you leave the firm, this is what we're going to do with the clients. This is what we're going to do with the fees. It's good to have all that in writing up front. but it can make a difference as to whether you're fired or whether you quit. And it seems like they're both saying, Whitney's saying you fired me, Anderson's saying no, you quit. And thank you to today's sponsor, HelloFresh. If you're tired of figuring out what's for dinner night after night, especially on those busy weekdays, get dinner done easy with HelloFresh. It's so easy to find time and to eat well with 50 wholesome, hassle-free meals to choose from each week delivered to your door. And it is the busy season in our house. Our kids seem to have something every night with sports, school, church events, nonstop. And we're always running to and from tag teaming it, my wife and I taking one here and one there. So it is so nice to still be able to get to eat together as a family. Awesome meals too, and stuff that we wouldn't cook on our own because they come up with cool recipes. They make it really easy to cook, and the food is delicious. Get up to 10 free meals and a free high protein item for life at HelloFresh.com/LYK10FM. One item per box with active subscription. Free meals applied as discount on first box, new subscribers only, and it varies by plan. That's up to 10 free HelloFresh meals. Just go to HelloFresh.com/LYK10FM. And I want to be careful about the part of this email I show. So Whitney sent this email, but Anderson attached it to a record or to a motion that he knows is going to be public because this is Florida.
Filing.
Good morning. This is from Nick Whitney. Following my termination from the firm on Wednesday, July 10th, we are required under Rule 4.4-5.3C1 to cooperate in drafting of a joint letter to the clients whose matters I primarily handled, notifying them of my departure and giving them the choice to continue with Anderson Glenn or elect to have me continue in their representation. To that end, attached is the Florida Bar's template letter modified to fill in the firm's name and mine, as well as the contact information. Blue text indicates information the firm will need to fill in. Please reply by close of business tomorrow with suggested revisions, if any. I request a list of all matters to which I've been primarily handling or otherwise assigned to that we can determine with clients, which clients will need to be notified via attached letter. And then he lists out the clients that he knows of that are going to need to be notified, and they attach the email with all the client names on it. It's not good. That's not what you should do. That should be kept private. That should be something that's confidential. Why don't you talk for a second about, you can talk generally because I know you've had to deal with this. And then if I need to add any Florida specifics, I will, about this letter. What is Nick Whitney talking about? Why is he sending this email? Why is he quoting the Florida Bar rule about what you do when people separate in a firm?
Yeah. So this brought back some, I think, post-traumatic stress. I don't know what I would call it, but about, I want to say 13 years ago, I was an associate attorney for an individual that is no longer a barred attorney in Virginia. But needless to say that relationship spoiled towards the end. I was handling 90% of the caseload. The other attorney was not handling any of the caseload. And it got into this contentious back and forth where I said, it was one of those where you ever seen like a show where I said, that's it. Here's my 2 weeks notice. And they said, hey, 2 weeks notice and you're fired.
You can't quit.
It was
you're
that.
Fired.
You can't quit. You're fired. So that resulted in me consulting the bar because I had already done so, thinking I was going to be leaving, and determining what rules existed for certain matters that I was handling. I was lead counsel. The client, in most cases, hadn't even met the other partner of the firm. So the bar required that we reach out to any matter on which I was primarily, and they say primarily, but it's basically any matter on which the lawyer is a substantial representing party, right? So you don't have to be the lead lawyer. You can be one of the lead lawyers that's on the case. And you have to notify the client that they have an option. They have an option that they can either remain with the firm, they can have their file transferred to the departing attorney, or they can have their file transferred to a new lawyer or to themselves to find a new lawyer. And you're supposed to send this, if you can, you're supposed to send it as a joint letter. If you can't, you're supposed to both send separate letters to each individual client with a little signature clause at the bottom where they sign with what their decision is going to be. And I will tell you that when individuals and when firms get to this point where they're sending letters, now you have a bunch of money on the line, not just money, but money and reputations. And it is just rife for conflict. So one, you can't usually agree which matters on which you're primarily tasked or where you're lead counsel or co-counsel. Two, there's oftentimes a little bit of billing adjustment done prior to those letters being sent. And then 3, after the letters are sent, there's oftentimes communications that perhaps should not be happening between the client and either the departing lawyer or the firm from which they're departing. But it's very, very tense, and the ethical rules surrounding departing attorneys are very strict. And I imagine they are in Florida as well.
Oh yeah. The whole point of all of this is we don't want to screw clients. We want the client to go with the lawyer that they want. There's no non-competes, right? If I have somebody that works for me and they go somewhere else, I can't say you can't compete in the same type of law that I practice, or none of my clients can go to you, because the client is always the king or queen, right? If they want to fire me and hire the person that left, they can do that. There is language in Florida that says like something like unless otherwise agreed to. So you can have a contract for an employment contract when you sign up saying, here's what we are going to do if you leave the firm. We get X percent, you get Y percent. We as the firm will decide which clients go to which, or which ones we're going to send the letters to, or whatever it may be. Or these are the firm's client unless we say otherwise, something like that. There are ways and language you can put in there. But at the end of the day, even if you agree to that and the client's like, no, I want to fire you and I want to hire them, that's the client's choice and they can do that. So when you write this letter, if there is no agreement, you write this letter, you send it out to all of the clients, and the client just basically decides, do they want to stay with Tragos, Sarson, Tragos, or do they want to go with John Smith, who decided to leave Tragos, Sarson, Tragos? And whatever the client decides, we have to go with. Now, you can deal with costs and deal with potentially splitting of some fees, or you can put into a contract like, if the client goes with John Smith, here's how we're going to split the fees. If the client stays with Tragos, Sarson, Tragos, here's how we're going to split the fees. But at the end of the day, the client's choice is which lawyer they are going to go with. And this is the appropriate thing to do. What Nick Whitney said he wanted to do is the appropriate thing to do, in my opinion.
Yeah, no, I agree. But it also comes down to where rubber meets the road. Mm-hmm. When the list of clients identified by Nick Whitney, right? If he lists clients that perhaps he was only tangentially associated with, and there's only a secondary relationship where he maybe drafted one motion on that case, but is now wanting to send a letter to that client saying, please come with me, the Anderson Glenn might have an issue with that. And then you've also got the conflict of what language. It can be stressful. So sometimes, and I'm guessing that from this email exchange, this might be one of those circumstances. Sometimes they just can't agree on a joint letter. And then each individual attorney is tasked with sending out a letter with language that they're supposed to be using from the rules. And then they kind of wait where the chips fall. But when they are not on the same page as far as what clients get the letter or what letter to send, then you will have the inevitable conflict over whether the matter is appropriately transferable, whether it does get transferred to you, and whether any fees get transferred to you, whether there's any unearned fees or money in trust or things like that.
Yeah, in your cases, like if you're billing hourly or have already been paid a chunk, it's different than like a lot of my cases is the fee comes at the end. So we haven't even gotten a fee yet. I have never had to do this, but I have seen the sample letter and sample language. And just like we do with our fee agreement, 99% of it comes from the Florida Bar standard language that they say, here's what you should use. And that's always a good starting point. And if a judge ever has to get involved, they're usually going to go with the person that wants to use the standard letter, not somebody that wants to put in a bunch of additional language, usually. But, to each their own. So the big meat of the discussion is going to come from this exhibit. Current counsel's revised response to the motion for substitution of counsel. So we're going to get into some background. We're going to get into some factual things that happened. And here's where it really the mud starts getting slung. Following Mr. Whitney's departure from the undersigned firm, and I'm reading from it for anybody that's just listening in audio. Following Mr. Whitney's departure from the undersigned firm, the Kowalskis went dark, quote unquote, a few days before Thanksgiving. The undersigned has heard nothing from Maya Kowalski since that time, even though for the past 7 years, they had monthly, if not weekly conversations, either by text, email, or phone. Jennifer Anderson's relationship, considering Maya no longer has a mother, was even closer. These circumstances of sudden silence are suspicious, to say the least. Thus, the current motion for relinquishment of jurisdiction and remand to the trial court. So, pulling no punches, right? I mean, even saying like Jennifer has an even better relationship than Nick Whitney could ever have because Maya no longer has a mother and there's a motherly daughter relationship there. And I'm very suspicious basically sounds like an accusation, like you just said. Sometimes there's some nefarious conversations going on behind the scenes with the lawyer and the client. Definitely seems like Greg Anderson thinks that's going on here.
Yeah, but when is it appropriate for the substance of those discussions to be the subject of a public filing? That's where I'm really concerned, because what you have in this pleading is now, mind you, this pleading is being filed as between counsel on the same side.
That's the crazy part.
This is not the plaintiff making an accusation as to the defendant or underhandedness being accused of the other side. This is the plaintiff's attorneys firing back and forth at one another. And in the process of doing so, they're putting at issue communications between the client and the attorney, inherently privileged communications. I mean, these are things that are sacred. Judges don't want to, hear this stuff, much less see them in written pleadings. So, yeah.
And this is a case where there's tons of sanction motions, finger pointing between the defense and the plaintiff's counsel throughout the entirety of the case and even after the case. And you have a situation where now the plaintiffs are doing it to each other. Not a good look. Starts to look like maybe you guys were the problem, not the defense. I'm not saying that because, God knows the defense did a lot of things throughout the trial and the process, but this is not a good look, period. This is why making this, public airing of your dirty laundry, everybody smells, basically.
Yeah. I mean, it's Howard Hunter, who's lead counsel for JHAT, Johns Hopkins All Children's Hospital, is just reading that first paragraph. Howard Hunter probably just cracked open a beer, sat down, and was like, this is going to be a fun fireside read.
Oh, I bet he loves it. He probably loves to see the infighting here. All right, back to the document. Although the purported new counsel's motion specifically represents that the undersigned were contacted by the movement before filing the motion to discuss it prior to filing, the undersigned counsel has never spoken to either Mr. Childers or Mr. Whitney about the motion, nor received any emails or texts other than a one-page directive infra. So another thing that happens a lot of times, lawyers or clients will fire one lawyer, hire another lawyer. You can have a standard letter that says, hey, your client wants to fire you and hire us. Here's their signature on it. Here's our fee agreement. Here's a copy. Here's where they signed it. Send us the file. We'll send you the cost for the file. That can be nice and easy in the middle of a case. At the end of a case, or not even the end of a case, but after a trial, it can get a lot more complex. This is the first time we're reading Mr. Childers' name, which is the firm that now Mr. Whitney works at, Childers Law Firm. And this is also going to be Whitney's new co-counsel representing Maya and her family. We'll talk about some issues that pop up with him as well. Back to the document. True, 5 months ago, Mr. Whitney emailed claiming termination and made attempts to take clients, right? As if writing that letter is something wrong. That's exactly what you're supposed to do. If you separate, you should write the letter like we just talked about. But any issues regarding the representation of the Kowalskis were resolved by the order dated July 30th, 2024 from the trial court. But as this is the second attempt to gain control, there has been no attempt to meet and confer in violation of Florida Rule of Professional Conduct 45.8C and the requirements of this court to attempt to resolve months before their filing. Resolve motions before their filing. Yeah, so you're supposed to meet and confer. You're supposed to deal with this. Sometimes it's impossible. Sometimes courts will hold you to it. Sometimes they won't if they realize that obviously this is a bit of a hostile relationship at this point. I don't think you guys are going to work it out. Some courts will still say you should have called, you should have tried to meet. It all depends.
Well, this one is also, let's point a little bit out here, because this is also saying that, Nick Whitney, for his part, yes, he sent the email, which is appropriate, but then all of a sudden you have a motion filed, which started the airing of the dirty laundry. And what Anderson Glenn is saying in response is, we're just having to complete the picture because the original opening door was opened by Nick Whitney. Again, infighting that you don't want to see.
Yeah, Nick Whitney definitely put too much information in his motion to withdraw. No doubt about that. You did not need to put all that information in there. Anderson tried to strike it, filed a motion to strike it, put too much information in there, like you said, responding. This to me feels more of like maybe Whitney did not technically comply with the rules. And it's a problem if he says at some point in some of these documents, I don't know, I read so many of them, we're only going to read 20 pages together, but he said somewhere that Whitney says we talked about it, we didn't talk about it. Whitney says he told me X, Y, and Z and he didn't. That's going to be a problem if you go to court and you never even let the other side know. And it almost seems like you are trying to do stuff sneakily, which no court is going to like. Rather, within 26 hours from the first contact by means of the directive, that Childers Law, a two-person bankruptcy firm in Gainesville, so that's the first little pot shot.
Shots
Anderson is
fired.
going to take multiple shots at Childers, at Whitney, and puff himself up as to why he's really the only lawyer that can handle this case. These lawyers can't handle this case. That's just one of them. Was now counsel to all three Kowalskis, four counting the estate. The purported new counsel filed the motion at issue in this court. Significantly, movements failed to direct this court to Judge Carroll's prior July 30th, 2024 order is itself a violation of the Florida Rules of Professional Conduct 4-3.3 as the duty to bring material facts to the tribunal's attention and Florida Rule of Appellate Procedure 9.380 as to notice of a related issue or ruling. For these reasons, the motion should be stricken and or denied with instructions for allegedly new counsel to follow the rules of professional conduct and rules of appellate procedure. By the way, jump in, put your hand up wherever. Feel free to interrupt me. But sometimes when I get reading, I just get going.
One question for you. So that's an important point. So it was the motion withdrawal that was summarily granted after the response was filed. And not only that, but Judge Carroll's order, from my recollection, called that he be stricken from the docket as counsel of record and not entitled to notices or anything else in the case, right? So it kept Greg Anderson. And now you're saying that Childers Law is the new counsel. So via Nick Whitney, the lawyer on behalf thereof, fails to direct this court to the order. What is, just as to leaving out a material fact?
Look at what this order is. I don't remember what this July 30th order is.
That's the one that basically says he's not counsel of record. It's
okay,
Greg
so it withdrew Whitney.
I don't understand how that would be failing to bring a material fact to the tribunal's attention if you're filing a motion to substitute counsel.
That's the appropriate motion as far as I'm concerned. If a client fires one lawyer, hires another, the appropriate motion would be substitution of counsel. You're obviously not going to be counsel of record, whether you've withdrawn or not, whether you're a new attorney or an old attorney becoming a new attorney again. That's the way you would put it before the court, I would think.
Yeah. And you're obviously, you're not doing anything wrong by saying, hey, judge, I know you had me withdrawn from the case. The client has made a decision, so I'm asking you to substitute me in the place of the person who's counsel of record by now. So I don't see anything wrong with how the motion is filed. I think the meet and confer part maybe, but
yeah. So I'll just tell you too, and maybe this is just a Florida thing. When there is a situation like this where the judge can read between the lines, the issues going on, usually they're not going to strike a motion like this. Or if they are, they're going to say, hey, do this, not that. But eventually they're going to want to get it in front of them to figure out what's going on.
Yeah.
Judge Carroll is going to hate to see this, just FYI.
Oh, yes.
For these reasons, the motion to be stricken. Okay. Upon receiving this thunderbolt out of the blue, the undersigned reviewed recent cases the firm is defending on behalf of the appellee, Kowalski's, and noted that movement, Childers Law, hereinafter Childers Law, or movement, has a direct conflict of interest under Florida Rule of Professional Conduct 4-1.7A1. Here's some issues he's going to bring up. Attached here too as Exhibit A is a complaint filed in the 6th Judicial Circuit of Pasco County on November 6, 2024. Movement here, which is Childers Law, entered an appearance on behalf of Trilogy, a trial support company that edited and showed depots at the underlying trial and ultimately charged the Kowalskis more than $200,000. The undersigned objected to the charges as an agent and representative of the Kowalskis, as the bill is outrageous. Though it names the Kowalskis' undersigned trial counsel as the party defendant, and that's what I was going to show. We don't need to look at the lawsuit, but you want to know who the defendant is? It's Anderson. It's not the Kowalskis, which is interesting but doesn't clear them. It is adversarial to the Kowalskis' financial interests. It is clearly a trial cost that is owed by the Kowalskis once the amount is settled. Attorneys are agents for their clients for all purposes, especially of this nature. For rules of general practice and judicial administration 2.505H, movement cannot sue its own alleged client, whether directly or through the client's longstanding agent. So this is an interesting question. It certainly reads like a conflict to me. Now, it is kind of weird because most costs, I've never had a cost like this that just waited till after trial. The law firm usually pays the cost up front and gets reimbursed at the end. So They didn't pay this cost up front, obviously. They're objecting to the amount now after the trial, after the services have been rendered, which is interesting. Do they have a contract? Do they not? If they do have a contract, who signed the contract? Was it Anderson? Was it the Kowalskis? Was it Anderson on behalf of Kowalski? Because it really is, there is a situation where it really could just be Anderson. There is a situation where that's possible, although unlikely, and it's
Very,
still connected.
very unlikely, because Anderson, as party defendant to that, would also be able to implead the individual who was ultimately benefited by the cost he incurred.
Correct.
So there's an action where he can implead a co-defendant in the defense of that. Where I read this and how I saw this was, my question immediately went to, what was Childers Law doing? Why did they take this? If you had in the back of your mind that you are former counsel to Maya Kowalski and you are suing to collect a cost from, I mean, you're suing to collect a cost from Maya Kowalski from the defense.
You want to know my
So
just my total wild speculation guess?
please.
I don't think they had any clue that the Kowalskis were ever going to come back to Nick Whitney. And I think Nick Whitney was like, F him. Let's
I think
take
Nick Whitney's
Trilogy's
conflicted
case.
out of this one.
What?
I think Nick Whitney's conflicted out of the Trilogy case. I think the conflict carries with him. He's suing a former client of his.
But Nick Whitney, it's Childers that filed the Trilogy lawsuit. So I don't know when Nick Whitney actually started working with Childers, right? So if it's pre Nick Whitney coming there and Nick Whitney's like, take this case, let's bury Anderson. I'm not saying that happened. I have no inside information. There's just obviously no love lost here between these lawyers, that maybe they did that first. Then Whitney joins Childers. Then the Kowalskis are like, actually, we want Nick Whitney. And now we're here. But you just mentioned it. One of the most concerning things about this entire document, Greg Anderson may have a very good point that it certainly seems like there could be a very real conflict of interest with the new/old lawyers that Maya and her family want to represent her, which would be Nick Whitney and Childers Law Firm.
And I think there is. And I think it's unwaivable. And I think Nick Whitney is actually conflicted. I think Childers Law is conflicted out of representing Trilogy. I think this conflict taints throughout all these proceedings. Because think about it this way. Irrespective of whether and when Nick Whitney knew about the Trilogy lawsuit, Nick Whitney joined Childers Law. This isn't a case where you can throw a firewall up and try to divide. This is directly adversarial to the other person's interest, to representation of a former client in a matter that stems from that prior representation. So Nick Whitney's prior representation of Maya Kowalski resulted in these costs being incurred by that case, by that plaintiff's action. Him going to Childers Law and then saying, I, on behalf of one of the vendors for this litigation at the case I'm going to sue to try and collect money back out of this. I think he's conflicted out of Trilogy. I don't think he can file a lawsuit against or be involved in a lawsuit against the estate.
So I think there might be a way they could plausibly argue they could build a wall for Whitney on the Trilogy case. If they already had the Trilogy case, they were already litigating it, then Whitney comes in, he won't have anything to do with it. I think there's at least an argument that they might be able to do that. But as far as the Kowalskis go, there just seems to be no way, right? I mean, they're both named as counsel of record for her in the substitution of counsel that they want to be, that this is who she wants to hire, not just Nick Whitney. It seems very ugly. And at the end of the day, if you have Maya Kowalski and her family saying, we don't want you, Greg Anderson, anymore, you're fired, we want these two lawyers, and the court's like, well, these two lawyers are now conflicted off. Now look who really ends up holding the bag at the end and gets screwed. Well, Maya Kowalski. Nobody's taking care of her once again. She is sitting in a position where it's a very complex case. Greg Anderson's going to explain in this document that nobody wanted this case. He took this case. He fought it for 7 years, put a lot of money on the line. And by the way, the fact that maybe he didn't pay some of these costs is because this was a very unusually expensive and long and difficult case. And not a lot of lawyers can just jump in and be like, if they are to lose on appeal, it's like, well, we got to try it again. No problem. John Smith can come figure it out and try it again. The best people to try this case again would be Anderson and Whitney. So now, once again, Maya is the one that could be in trouble because of all this infighting with the lawyers, which some people could say it seems like it has a lot to do with money. All right, back to the document. Further, the undersigned has some suspicions regarding the signature of Maya Kowalski attached to the motion. So this is where Maya actually signed that she wants Whitney and not Anderson. He's like, I don't know if that looks like her signature. Although due to the holidays and with knowledge of a life-threatening illness of Jennifer Anderson, Greg Anderson's wife, the undersigned begs the court's indulgence as it is hard to manage family and a very sick wife over the holidays and locate appropriate experts. Current counsel has yet to have a handwriting expert review the signature, but will if given the opportunity. But that does not mean he should not raise the issue. So basically, Anderson's saying, I don't think that's her signature, although I don't have any proof of it at this point. Based on the fact that undersigned has reviewed and observed the signature of appellee Maya Kowalski on countless occasions over the past 7 years, that does not appear to be her signature. So basically he's saying, I'm not an expert, but I've seen her signature a lot. And it doesn't seem like her signature endorsing the motion. Alternatively, it does not appear to be an original, but perhaps one transferred from another document at someone's direction. So
That's
now he's
a heck of an accusation
with no proof.
That is an implied accusation that you basically took one signature from one affidavit, one signature from one document, and based on authorization, you basically grabbed that signature and transmuted it to a different document. That is a big accusation. Not only that, but I don't know what Florida signature rules are. Are you guys electronic signatures yet?
Yeah.
And we are too. And it's something where certain documents don't have to have an original signature on them.
Right.
I don't know if this is the case.
I don't know if this would be one of those, but or no, yeah, no, for sure. Yeah, we've done this exact thing with an electronic signature. Actually, I don't know if we've done it on actual substitution of counsel motion, but we've done it on like letters where we send firing an attorney, hiring another attorney. It's been by electronic signature. I'd have to look. I don't know for sure the answer to that. But he's not only saying that, and it's also weird. If it was taken from another document, then it must be her signature, right? Because it's like you can tell this was taken from another document that doesn't really jive with this isn't her signature. So it's either forged or taken from a document at someone's direction. It could be Nick Whitney's direction. Definitely sounds nefarious, like something shady is going on here. The undersigned is bolstered in his belief in this, as he has personal knowledge. Maya Kowalski has been living in California for large portions of the past 3 months at the home of the undersigned's sister and brother-in-law in Rancho Santa Fe while she explores choices of universities. So she's living at a family member's of Anderson's house for the past 3 months in California, just to add insult here. It is the intention of the undersigned counsel to have her signature reviewed by a handwriting expert as soon as practicable. Or we could ask Maya. It may well be.
Do you know how bad it's going to be if, you know how terrible it's going to be if it was Maya's signature and she gets up and says, yeah, I signed it. And all of these paragraphs essentially accusing Maya or accusing Nick of doing something that Maya authorized. I mean, this is a whole lot of putting, I don't know. There's a lot of spent powder for something that might not result in the best circumstance for any of the parties involved.
So then let me read this next question or next paragraph before making my point. It may well be that the signature provided in the motion is appellee's signature, but until the circumstances of the 19-year-old appellee's consent are investigated, the motion should be stricken as to Maya Kowalski. So yeah, let's say he has a handwriting expert like, oh yeah, that's a different signature. And then she's like, no, that is my signature. No, I don't want you to be my lawyer anymore. I want Whitney to be my lawyer. Then it all doesn't really matter, right? But even more important and concerning to me is that he is basically calling into question Maya Kowalski's consent as a 19-year-old. And my question would be, over the past 2 years, since she was 18 and 19 years old, years of majority and adult now, how many documents do you think she signed? How many decisions do you think she's made? How many things do you think she's done that Greg Anderson has been the one saying, do this, sign this, let's talk about this, let's get to the bottom of it, and she's had the ability to do that?
Even going back to the final judgment, when they were debating entry of the final judgment on this case, I don't know if you recall that, but the case was initiated, Jack Kowalski as next friend. So it was initiated as a next of friend case, which is basically an adult bringing the case on behalf of a minor. They are standing in the shoes of the minor. Well, Maya turned 18 during the end of this litigation.
Mm-hmm.
At the end of the trial, she had actually turned 18. And before the judgment could be entered, the judgment had to accurately reflect who was the party plaintiff. And the party plaintiff at that point in time had attained the age of majority. So Florida, this court specifically recognized in changing the name on the style of these pleadings to Maya Kowalski and in changing the judgment to be in her favor, not in favor of Jack Kowalski as next friend to Maya Kowalski. The court here recognized that Maya had attained the age of majority and was sufficiently capable of adjudicating her own matters and providing consent because she was the prevailing party at that point.
Yeah, I mean, a lot of times if that happens to us in cases, we'll do new fee agreements. Mom can't sign for you anymore. You've got to sign your own fee agreement now. You got to make the decisions now. You got to sign the documents now that you're 18 years old. And this next paragraph says, given the importance of a voluntary, knowing, advised, and properly managed transition, any question in this regard should be resolved in favor of forbearance of changing counsel after a 7-year successful relationship. Factual issues predominate traditionally. The role of the trial court, particularly as here, where the trial court already has once decided the issues. So again, to me, there's no case law here. There's not like, hey, judge, we've had cases where something like this happened before. He's basically, to me, it feels like saying, we feel like Nick Whitney is pressuring or committing fraud to make it seem like Maya Kowalski wants him as her lawyer now and not me anymore. That's what this sounds like to me. It's just like some allegations that something bad is going on in the background and we need to investigate this together, judge.
But let's play this out. Just logically speaking. What does it matter? If an 18-year-old who has the legal authority to consent for anything issues a directive, even if that directive is foolish, even if it's not the smartest thing strategically for the 18-year-old to do, they have agency. They are allowed to make certain decisions, even if they're not in their best interest. This is not a criminal case where someone is entitled to the right to counsel. This is a civil matter. That person's directive, no matter how foolhardy it is their directive. And where does the court have the authority to step in the shoes of that individual who can vote, who can make decisions about their own life, who can make decisions about their medical treatment? Where does the court have the authority to supersede that person's individual judgment on who is their attorney in a civil matter?
That's exactly what I'm saying. That we're saying the same exact thing. So basically, all he can really be saying here is Nick Whitney pressured and forced Maya to do this. And if we can just talk to Maya together, judge, me and you, we can get to the bottom of it. That's really his only argument.
Or get her to change her mind.
Right. Which the court should have nothing to do with that.
No.
It's not good. All right, here's the memo of law it's more interesting things coming. Undersigned counsel for the Kowalskis has represented the family since May of 2017 when the first spoliation and 627 letter were sent out, culminating in them serving as lead trial counsel at the 8-week jury trial in the fall of 2023 of some repute resulting from the Netflix documentary Take Care of Maya. Undersigned counsel for the Kowalskis filed suit in 2018. Over the course of the 7 years it took to get the case to trial, including a writ of certiorari to this court in 2022, the undersigned counsel and firm worked tirelessly in the hopes of obtaining a favorable verdict for the Kowalski family, which included litigating over 3,800 and counting docket entries. The undersigned succeeded, subject to this appeal, of course. The combined docket approaches 4,000 entries at the combined trial and appellate level. After the incredible financial constraints of supporting the millions of dollars of costs and deficit spending of the firm, the Andersons sold their home on Intercoastal Waterway to downside their costs of living and accommodate the multiple lines of credit necessary to keep the case going and the firm of Anderson Glenn LLP alive. So it doesn't sound great. Like you don't want to be put in this position to where it seems like desperation, right? But fighting for his client in a case that he believed in, he was willing to like put it all on the line basically. But you can understand now how I said in the beginning that appeal can create a lot of stress and pressure on most of the time the client. It's not good when it's creating that stress and pressure on the lawyer because they do things maybe they wouldn't normally do. And we're getting this infighting and pointing the finger at two lawyers that were literally, I don't know if they were partners, but working in the same firm together very recently. and very successfully. Mr. Whitney was a former, so here's some shots now, okay, some shots. Mr. Whitney was a former partner of the undersigned firm. Okay, so he did make partner. Mr. Whitney had nothing to do with bringing the Kowalski matter into Anderson Glenn, as he was not even employed there at the time. So this is when I mentioned if you land the case, if you bring in the case, usually you get a big chunk of the fee. Well, he's saying, just to be clear, Whitney had nothing to do with that. As a second-year associate, his role was to support. Even upon eventually making partner, he had no direct responsibility for any aspect of the case. Any involvement by Mr. Whitney was carefully supervised prior to this case. Here we go. Prior to this case, Mr. Whitney had one case where he was first chair jury trial, carefully selected for him because it was a rear-end, stipulated liability, whiplash case, which the undersigned counsel believed to be unlosable. So basically, I gave this young guy the easiest case in the world. As his only trial, he's going to go first chair, meaning be the lead lawyer at trial. He couldn't lose. Nobody could lose this case. Well, guess what? Mr. Whitney lost. So basically, the only purpose, and Rob, correct me if I'm wrong, because sometimes I can be a little cynical. The only purpose of putting this paragraph in is to be like, Mr. Whitney doesn't know what he's doing, is not a good lawyer, should not be the lawyer Maya picks, cannot handle this case on his own. I did everything in this case. He did nothing. Mr. Whitney can't handle this case.
I would say that's the only purpose of that paragraph and the one preceding it. And it's one of those things where you see a lot of this debate over, I brought the case in, I litigated this for 8 years, I incurred all these costs. I understand that. We're not having a debate or argument over whether or not you get your fees paid. That's not subject to debate. You have a fee agreement, you get your fees paid. We're having a debate over whether or not you will remain on as counsel going forward, or this substitution of counsel is valid, and Maya gets to choose where the case goes from here. So a lot of this seems to be an argument over, this is why I should get my fees, and Mr. Whitney should not get his. Very little argument over whether Maya has the ability to make a choice or not.
I mean, this is not a capital death penalty criminal case. Clients are free to make the mistake and choose the wrong civil lawyer if they want to. Not that I would ever want that to happen. They can pick somebody who hasn't worked 1 second on this case, right? And that, a lot of times that's what happens if they go to a new lawyer. This is not that, though. Whitney was sitting there throughout the trial. The trial court judge is going to know that. The Kowalskis obviously know Whitney. Are they making a bad decision? Maybe. I don't know. I'm not going to sit here and say one lawyer will be better than the other, or they should pick this or that. But what I will stand up here and say is they should be able to pick their lawyer, period. They should be able to pick their lawyer. That's what I firmly believe in. After now almost 8 years of dedication to this case and the Kowalski family, just like you said, it almost sounds like he is saying why he should keep the case. Regardless, it's like almost a plea to the Kowalskis is what this sounds like. After 8 years of dedication to this case and the Kowalski family, undersigned counsel and the firm achieved a favorable verdict during the 8-week jury trial in the fall of 2023 of $261 million, remitted by the trial court, meaning dropped down by the trial court to $209 million. Subsequently, undersigned counsel selected appellate counsel and worked with the Gunster firm in identifying and responding to the likely issues defendant appellants might raise on appeal. After sitting, quote unquote, second chair at the 8-week trial over the fall of 2023, Mr. Whitney quit Anderson Glenn in mid-July of 24 without notice or the customary 2-week pre-departure period to allow a smooth transition of clients. I will also just throw in here in Florida, you don't have to give 2 weeks notice. You should, you can, it's appropriate, it's respectful, it's nice, but there's nothing illegal about not giving 2 weeks notice.
Yeah, let me tell you what most employers do when an individual gives 2 weeks notice. They do this lovely thing called, we waive the 2 weeks. You can leave today.
And guess what?
Especially when you're relationship driven, when your business is relationship driven.
And guess what? I can understand the arguments on both sides of that. Is this employee going to poison the well? Are they going to talk bad about me while they're still working here? Are they going to get any work accomplished these last 2 weeks? And from the employee section, I hate this person. They were so horrible to me. It's a hostile work environment. Do I really need to stay here for 2 more weeks? I get it. Not every relationship is perfect. In a perfect world, it's like, hey, I got this better job, better paying job. You understand, you said this is the most you can pay me. I really don't want to leave you hanging. I'll stay here. I'll help train the next person for 2 weeks. Okay, great. Congratulations. I'm happy for you. You got this new job. Help me train this person. Sure, sometimes that happens too. But yeah, it's you can see arguments on both sides of this to where to throw this into a pleading like this to me again is a personal pot shot from Anderson. Yeah. Undeterred, Mr. Whitney proceeded to file a noisy withdrawal with the trial court in his first attempt at a client grab. Since he was never individually counseled to the client, his withdrawal was not only unnecessary, but in it, he revealed privileged and confidential information. In response, Jack Kowalski filed a detailed affidavit making clear he was staying with Anderson Glenn. The trial court made quick work of Mr. Whitney's attempt, ordering he be removed from any representation. So again, at that time, there was an affidavit by Jack Kowalski saying, I want to stay with Anderson Glenn, which was the Kowalski conglomerate, including Maya, and they seemed to be in lockstep with Anderson Glenn. So what happened? And it seems like Greg Anderson's like, I don't know what the heck happened. And that's why it seems like he thinks Nick Whitney in the background got in Maya's ear or Jack Kowalski's ear, changed their mind, turned them against Greg Anderson, and now wants to hire Whitney. Or doctored documents, forged signatures, and did other illegal stuff to get this case. The reply brief on the merits of this appeal was filed on September 27, 24, concluding the briefing process. The undersigned, did you read the briefs?
I haven't yet, no.
I haven't either. A couple people asked. I'm like, I don't usually read appellate briefs, but maybe Rob will. And if he does,
the fact that all the briefs were in, I wanted to wait till all the briefs were in before I even took a look at it. Now that the reply brief is in, which is the final brief before oral argument, it now seems like it might be an appropriate time to take a look at that.
Awesome. Well, maybe I will pop onto your stream while you're breaking them down. I am probably not going to do entire appellate briefs. I don't have the stamina like Rob does to do like 5 hours. The undersigned was and remains involved in representing Maya Kowalski in a number of matters, but then received a December 19th, 2024 letter where they were informed that his wife, Jennifer, who had been a second mother to Maya and the firm. I mean, it's wild how deep they're going with this. Like, were being replaced by Mr. Whitney and his bankruptcy firm in Gainesville, Florida, Childers Law. Make no mistake, there is sarcasm and condescension coming from Greg Anderson's words here. It is now, only after virtually all the work has been completed, that a letter, not from the Kowalskis and without explanation, arrived, notifying Anderson Glenn that Mr. Whitney's new firm would be taking over the matter. By the way, that's okay. You're allowed to do that. And we're going to get to his lien letter. That doesn't mean Anderson wouldn't get paid. He would still be entitled to fees. He would still be entitled to fees based on the contract, depending on what the percentage was, or in certain circumstances, quantum merit, which is you get paid for the hours that you work for an appropriate hourly rate. It's not like he's going to get screwed out of fees. These are fees that are if they win on appeal, these are fees that are already earned and realized for Greg Anderson at this point. It's not like he would lose his fee because she switched lawyers at this point.
And by the way, there are whole firms that will do auditing to determine what fees were resolved, especially in a case with this type of judgment. So, I mean, you can hire a forensic accounting firm to go through and determine a fee allocation appropriate between two counsel in a case. It's not hard.
Current counsel has heard absolutely nothing directly from the Kowalskis concerning any issues, any objections, any controversies, indeed any problems whatsoever prior to allegedly being discharged, at least until last week when Mr. Kowalski sent an email with banking instructions. They are no doubt following instructions from Mr. Whitney and Mr. Childers to refuse to communicate with the Andersons and the firm. Heaven only knows what Mr. Whitney and Mr. Childers have told our client to whom we have given everything. So first off, he says they haven't heard directly from them any issues. Number one, you don't have to. And that's actually purposeful sometimes because you don't want a client to have to be like, hey, you're fired. And you have an angry lawyer who argues for a living and convinces people for a living to fight with that client to stay. But then he says, well, we didn't hear anything until last week when Kowalski sent an email with banking instructions, which again indicates they are with Whitney and Childers. But then what does he say to take it a step further is that only heaven knows what Whitney and Childers are telling our clients to whom we have given everything.
Here's another problem that he's running into here is, let's say that you're reaching out from Anderson Glenn after being discharged or receiving a discharge letter, and that Maya Kowalski, Jack Kowalski, and others are represented parties. Are you now communicating with a represented party? And does that
Theoretically,
have its
yeah.
own ethical implications?
Well,
I
yeah,
mean,
but I do think there's a circumstance where you think you still represent them and you think there's a problem and it's not right. And, that's what you're looking at. I think you're right. Like in an abundance of caution, that's how I would handle it. I would not reach out to them if they have another lawyer. I would reach out to that lawyer. Like I have had situations where if a client left, I'm like, hey, tell me what's going on. I'll reach out to the lawyer. I mean, tell me what's going on. Okay. They want to do this. Okay. I'll send you the file. Here's the amount for cost. Send it to me. I've done the same thing where lawyers have reached out to me. I explained, hey, they just didn't feel like they were getting enough information. They felt kind of lost and they wanted to change or whatever. It happens, right? It happens. This is very
you
different,
guys
obviously.
and you guys have bar counsel down there, right? So
Ethics
if
hotlines
lawyers
on
have,
speed dial, baby.
that's what I mean. That's and I imagine they have an email address too. You just
Oh
shoot them an
yeah.
email, pop them a
Send
note,
me
give them a
send me
call.
the opinion that you're relying on here so I can save this opinion to the client's file. So if anything ever comes up, I can be like, I called the ethics hotline. This is the opinion they gave me. This is what we relied on, and that's how we acted accordingly. We do it every time.
First phone call. First phone
It's
call
easy.
in this instance when this would have come up. You better believe it's not just a phone call, but I'm phone call, email, give me the documentation. I'm saving it. I might append the documentation provided by the ethics hotline to any motion I file with the court. And you know what I'm doing also is I'm requesting leave to file anything in this regard under seal. I'm not doing it publicly. And I don't know whether it's, first shot fired public, therefore everything responds to public. I don't know, but there is no way that this should have seen the light of day. But now that one part of it has seen the light of day, there's not good cause to strike the remainder of it.
It sucks. It really sucks. And the ethics hotline and stuff like that, it's the easy, clean way to do it so you don't have to worry. Like it's how you sleep at night. Uh, the letter was received via email on December 19, 2024 at 1:07 p.m. And the physical letter was not received in the mail until the morning of December 27th, over a week later, obviously Christmas and Christmas Eve. The letter did not include the motion for substitution of counsel for current counsel's review, nor did it ask if current counsel had objections. Current counsel received no phone calls, no emails, no texts, nothing explaining the basis or requesting a conference to discuss the issues amicably to resolve them. And the same was true from the Kowalskis. Nothing, despite the fact that there has rarely been a week or even a critical time, at critical times, a day without communication since the case was filed in 2018. The letter does not order the undersigned not to contact their client, and the clients have refused to respond to texts, emails, or calls. So it kind of sounds like he did reach out to them, right? Less than 24 hours later, and without waiting for a response from current counsel, Childers Law filed the motion for substitution of counsel with the trial court. So I do agree with him, with Greg Anderson, that they should have put the motion for substitution of counsel, asked if he had any objections to it. They should have asked for that. They do not need to call and explain why the Kowalskis are firing Anderson and hiring them. They do not need to do that, in my opinion.
No, usually what we do, and I'm in domestic relations. I mean, clients go from lawyer to lawyer like you wouldn't believe.
They
So
hire you
it's
first
very
because their husband can't hire you or their wife can't hire you later, right? I've heard that happens.
it does happen from time to time. But no, it's relatively routine where someone feels like, and honestly, lawyer client relationship, especially in domestic relations, is very personal. You have to vibe with your attorney. And if you're
Yeah.
not the same vibe, it's not going to work out. And if it doesn't work out, which it doesn't often, I mean, sometimes it doesn't, it's very routine for me to get an email or for me to send an email to another attorney with simply a substitution order. I don't have a motion there. I just have a sub order that says, here's a line item for you to sign. Go ahead and sign the sub order. And maybe there's a back and forth. Maybe. But you send it to them and say, would you mind signing this? And it's relatively routine that it gets signed and sent back. But you give them an opportunity to sign it and send it back before you file a motion asking for that relief.
Mm-hmm. The statements made in the motion for substitution of counsel are material misrepresentations made in violation of the Florida Rules of Professional Conduct. Paragraph 4 says Gregory Anderson of Anderson has been notified of this motion, and it says that he didn't object to it. That's a material misrepresentation. The above detailed representation makes it seem like current counsel has provided the motion. Okay, the judge will deal with this stuff. Like, did he notify him? Did he not appropriately? He says he wasn't given enough time. His wife was extremely ill. Rather than curtly state that the undersigned was no longer counsel and was not inviting a response on the matter. So this is just basically him saying the communication was not appropriate enough, didn't give him enough time to respond to it. In light of the conduct described above, current counsel would like to direct the court's attention to a 2018 Supreme Court case where the court found an attorney violated the rules regulating the Florida bar when he knowingly made a material misrepresentation to the tribunal in a proposed order by stating, counsel for the defendant has interposed no objection to the motion. So guess what? Anderson's probably going to want some sanctions, right? I mean, how many sanctions motions were filed in this case? More than any case I've ever seen in my life. In actuality, the attorney failed to give counsel for the defendant any notice of the motion, thus making it impossible for the defense counsel to state if they had an objection or not. The court found that that statement made in a proposed order was a material misrepresentation in violation of the Florida Bar 4-3.3a. Listen, that could be an issue. That could be an issue. And it could be something that was a material misrepresentation. I don't know. We'll see Whitney's response, see if he said, no, it was attached, you just didn't see it, or whatever. While the representation by the movement, Childers Law, is correct, the undersigned do object. It is the fact that there was no notice or discussion that is concerning. Yeah, so they assumed he was going to object, which he would, but they didn't actually ask him and give him the opportunity to object, which is not appropriate. You can't just say, I assume they're going to object, I'm going to file it anyways. You can't do that. You have to ask, give them the opportunity to object, and then say they do object.
Tell me you haven't written one of these emails that says, I intend to file a motion. I assume you object. Like you written that email.
Correct. But I usually won't say they object until they respond.
Yeah. Well, I every now and then I'll throw in a little shot saying, I assume you object. Are you okay for a motions day?
Yeah, absolutely. Absolutely. No conversation has occurred with current counsel between any of the involved parties. Current counsel has not heard from the Kowalski family regarding their discharge as counsel, in which I don't know this to be true, but I assume that Childers Law said the Kowalskis want to fire you and hire us. That is communication from the Kowalski family. I know what Anderson means. He means from the Kowalskis directly from them and not from their new quote unquote counsel or agent, Childers Law. As such, at this time, current counsel remains completely in the dark as to why and how the decision for substitution of counsel was made. He just doesn't have to know. You don't have to tell your lawyer why you're firing him.
And that might really look. Let me put it this way. I feel for Greg Anderson, Jennifer Anderson in this. I feel for all the parties in this. You know, you take a case, you represent it, you put your heart and soul into it, you put your financial stake, your firm behind it, you do all these things, and you just want to know what happened, why, what is going on. And you want the opportunity to explain but the way the rules are written, as the lawyer, you don't get that. You're not entitled to that.
And you can understand why. Like, we are, generally speaking, confrontational. Most lawyers, most litigators, and a lot of people are not, especially people that are our clients. It's uncomfortable. It's difficult for them. So the court doesn't want to set up a situation where you have to go into your lawyer's office and meet with him and explain why you're firing them. Like, good luck. That's most people's nightmare to go do with their lawyer. So I can understand that. I will also say Greg Anderson is 100% correct that he took this case that I don't know if no one would ever take this case, but not a lot of people wanted this case. Not a lot of people believed in this case. He put it all on the line. Sounds like he put a ton of money, his reputation, his law firm on the line. He knocked it out of the park. Whatever you want to say about his style or the way he presents or whatever, to the tune of $260 million, that's an absolute victory any way you want to draw it up. No doubt about it. He absolutely did that. He was successful in doing that. And this doesn't take away from that. If they want to switch lawyers, he still deserves every single thing he earned over the last 7 years. And I don't want to take any of that away from him or act like I am. I just hate this. I hate this lawyer infighting from people that are on the same team, that are fighting for justice for the client they both believe in. And now they're letting this get in the way of working together for the ultimate just result for Maya that the jury found in her favor. That's what sucks.
Yeah. Well stated. I don't know if I could have stated it that way. Thanks for hitting the nail on the head for how I feel.
I've had people call me with similar, not exactly the same, but some kind of indirect similar allegations. And it's just so hard to prove, so hard to go through, might take 7 years. You might never win. If you do win, you might never collect. So he took a real risk here. This was not some slam dunk case. I know when a lot of us were watching the trial, we're like, oh, this is going poorly for J Hatch. This is going poorly. But when the case was first taken, it was not a slam dunk. Current counsel has attempted to contact Childers Law since the receipt of the motion for substitution of counsel, but has not received a call back. That's not great. Like,
No.
be a man, pick up the phone and talk to them about what's going on. You could say, I can't reveal client confidential conversations, but they're hiring us and firing you, and no hard feelings. Just send us the file. If you think there's a conflict, okay, go ahead. We'll discuss that issue, but pick up the phone and talk to them. The representation made to this court in paragraph 4 is misleading to the tribunal because there's been no communication. Quote unquote, new counsel should be prohibited from representing the Kowalskis due to a current and direct conflict of interest. So this is where we'll get to a lot of what you said already. Current counsel would like to bring the following current and direct conflict of interest to the court's attention. The alleged new firm, Childers Law, is representing Trilogy Trial Consultants in a matter against undersigned counsel. Attached here too is the complaint. The action in the attached complaint arises from Trilogy's role as trial support company for the Kowalski's trial in the fall of 2023. Trilogy submitted an excessive bill, which the undersigned counsel objected to on behalf of the Kowalskis. As counsel for the Kowalskis and pursuant to Florida Rule of General Practice and Judicial Administration 2.505H, the undersigned firm has been charged as the Kowalski's agent in all court proceedings for the past 7 years. As such, part of the firm's responsibility entails protecting the Kowalski's financial interest, including disputing excessive fees and costs associated with litigating their case. We've already talked about a lot of this. Okay. As a former partner of the undersigned firm, Mr. Whitney knew of the concern for the amount charged by Trilogy and its exaggeration of services. But I thought he wasn't really involved in this case at all. How would he know?
Yeah.
Meaning Mr. Whitney is a material witness. Mr. Whitney's new position at Childers Law creates a conflict for Childers' representation of both the Kowalski family and Trilogy. Next, under rules regulating the Florida Bar 4-1.7A1, a lawyer must not represent a client if the representation of one client would be directly adverse to another client. That seems very obvious here. This conflict is imputed to the entire Childers law firm. The amount in controversy for the matter raised by Childers Law on behalf of Trilogy is approximately $200,000. While the lawsuit is pled against undersigned firm, that money would come from the pockets of the Kowalskis as a trial cost. Correct. Further, the effort by Trilogy was for the benefit of the Kowalski family, as noted. Just like what you said. As noted in paragraph 36 of the attached complaint, Mr. Reyes assured Anderson, I will make sure we have the tools we need in the courtroom to put on the very best visual presentation for Maya and her family. Therefore, an adversarial relationship exists between the reported new firm and the Kowalskis as represented by current counsel. Undersigned counsel is aware of the exception for the informed consent detailed under 4-1.7b of the rules regulating the Florida Bar, but no facts have been offered to demonstrate either party knows of the conflict, provided consent, and subsequently waived the conflict. In any event, suing one's own client, even through their agent, cannot be waived. So what he's talking about here in paragraph 39 is a conflict waiver. Do they know what's going on? Did they waive that conflict? And then if they did, is this even a situation where you can waive that conflict? Usually suing one of your clients, suing the other client, not a waivable conflict, not something you can do. All right, let me read this paragraph, then we'll get your thoughts. The comments to the rule regulating the Florida Bar 4-1.16 state, even if the lawyer has been unfairly discharged by the client, a lawyer must take all reasonable steps to mitigate the consequences to the client. So that's what Anderson says he's doing here. In keeping the aforementioned comment in mind and undersigned sincere interest in doing what is best for the Kowalski family, as up until recently, they had been devoted clients to the undersigned's firm, undersigned believes it is his duty to ensure the Kowalskis were made aware of this conflict and provided proper informed consent pursuant to Rule 4-1.7b. So it would really suck if the Kowalskis didn't know about it, and this is how they found out. So after hearing that, we've already kind of heard your thought on the conflict. Just kind of your final answer, would you say that Childers and Whitney are conflicted off both cases, and therefore, if Maya has fired Anderson's firm and wanted to hire Whitney and now can't, that she is left lawyerless at this point?
Yes. And I hate saying that. I really hate saying that. I hate that this got here. I hate that any of this happened, but I do not believe this is a waivable conflict. I think the conflict exists because if you actually play this out to its logical conclusion, you have Childers Law that sues Greg Anderson. Greg Anderson has an absolute right to say that these costs were incurred as a cause of the litigation, even if it was, 10% of those costs, right? So $20,000. That should be attributable to Maya Kowalski. He in-pleads Maya Kowalski, and then Childers gets a judgment on behalf of their client Trilogy that results in a judgment against Maya Kowalski, their current client. You cannot do that. And it is unwaivable because you cannot have a directly adversarial proceeding from one client versus a former client.
And the whole point is Maya would be arguing, no, they
Yeah.
didn't deserve that amount of money. They didn't work to the tune of $200,000. That would be her position, which is in direct conflict of their other client.
Even if that wasn't Maya's position, that would necessarily be the position taken by the zealous advocate that was tasked with representing her. Even
It
if
should be
Maya
her
said,
position. Yeah.
yeah, even if Maya was the one that says, I don't care about this dollar figure, a lawyer can't do that because they have an absolute duty to represent their client zealously and advocate for every position in their favor. So,
And honestly, sometimes the rules are put in place to protect clients from themselves. Right? Because you don't want to be put in a position where the same lawyer is telling you, oh, yeah, let that client have 200 grand. Oh, they're also a client of ours as well.
This is where conflicts come up in joint defense agreements, where one defendant wants to point the finger at another. You can't represent both.
All right. Contact with the Kowalski family made by Mr. Whitney was in violation of the rules regulating the Florida bar. Undersigned counsel next asks this court to consider Mr. Whitney's conduct with respect to the Florida Rule of Professional Conduct 4-5.8C, which states as follows, which I'm not so sure this is even appropriate for the trial court to consider, but lawyers leaving law firms, absent a specific agreement otherwise, so that's the agreement I was telling you about that you can contract to how we're going to deal with this. A lawyer who is leaving a law firm may not unilaterally contact those clients of the law firm for purposes of notifying them about the anticipated departure or to solicit representation of the clients unless the lawyer has approached an authorized representative of the law firm and attempted to negotiate a joint communication to the clients concerning the lawyer leaving the firm, and bona fide negotiations have been unsuccessful. So many words in there that you can tell lawyers written like a bona fide negotiations. What does that mean? But yeah, so he's saying like he didn't do all the conditions precedent, meaning all the stuff he needed to do first before reaching out to Maya. He just reached out to her. Mr. Whitney appears to have go ahead.
That last sentence, that's got to be a unique caveat because that's not in our rules, the bona fide negotiation thing. Usually it just says good faith effort, right? This is obviously the bar got sick and the Supreme Court got sick of the lawyers just saying, this is my good faith effort, and then proceeding. And they were like, no, we're going to require this added step. But what does that even mean?
It's like a reasonable person standard. Like, were you negotiating? It's like arm's length negotiations. And it's all just like, did you guys try? And everybody's definition of that would probably be a little bit different. I hate stuff like that. Mr. Whitney appears to have contacted the Kowalskis in violation of this rule. At no point since his exit from Anderson Glenn has Mr. Whitney attempted to reach out and conduct bona fide negotiations with Anderson Glenn related to informing the Kowalskis of his departure from the firm. I would disagree. I think the email that he sent was good enough and they could say yes or no. And if they wanted to change something, they could have told him. I don't know what the response to that email was, or actually, I think we read the response to that email, and she basically ignored it and said, you're not fired, you quit.
Yeah. And you actually don't get to just ignore the substance of an attempted communication and then say they didn't communicate with me.
We didn't
I didn't see it, or that was a bona fide attempt saying, here's what I propose we send to all of our clients, and here's the list of clients that these get sent to. That's a good faith effort.
The lawyer has approached an authorized representative of the law firm and attempted to negotiate. As such, any communication by Whitney to the Kowalski family was in violation of Rule 4-5.8C1. Mr. Whitney clearly understood the Kowalski's commitment to stay with the firm of Anderson Glenn as a result of the affidavit of Jack Kowalski filed in opposition to Mr. Whitney's noisy and totally unnecessary withdrawal from the case after his departure from Anderson Glenn in July of 2024.
Now, here's where there is a question. That withdrawal takes place, right? There's got to be some window of time where Greg Anderson makes a point that it might be a pretty good point. A window of time during this messy conflict when communications were occurring between the Kowalskis and Nick Whitney before any of this stuff was formalized. And is there an issue with some of those communications?
So there's two ways this can happen, right? You're right. Whitney could reach out, convince him to come to him. That would be totally inappropriate. Or Whitney could send that joint letter type of deal that he wanted to send. That could have started the conversations and the Kowalskis reach out. Or something happened with Anderson. He didn't respond to emails. He didn't respond to a phone call. They lost trust in him for some reason. That happens too sometimes. I'm not saying it did, but something negative could have happened on this side for them to look elsewhere, right? And where would they
Yeah.
look first? Maybe Whitney. I don't know. But there are other explanations than Whitney doing something nefarious. Now, if he did do that and he did violate these rules, then that's something that should be taken up with the ethics department. Suffice to say, Childers Law and Mr. Whitney contacted the client of Anderson Glenn unilaterally and with no legal or ethical authority to do so, and likely poisoned the relationship. Without undersigned counsel even knowing what's going on and no ability to defend themselves, Mr. Childers and Mr. Whitney told tales for one purpose: separate the Andersons and the firm from their long-term client. Further, the new lawyers instructed the Kowalskis not to speak with or respond to their counsel of 7 years, giving us no ability to even address the allegations so the Kowalskis can learn the truth. That is just, I hate it. I hate it for Mr. Anderson. That is just not how it works. You're not allowed to just say, they trust me, they're with me, they filed this affidavit. Well, now they're doing this. Well, the only reason they're doing this is because some other lawyer lied to them, poisoned them. If they knew the truth, they would be with me. You don't know that to be true, right? You don't know that to be true. And I think that stating that as fact creates some difficulty around this situation entirely, because it could just be the Kowalskis wanted a different lawyer. And that could be a bad decision maybe on their part, but it's a decision they're free to make. That's the issue.
Yeah. This also places the focus on the wrong people in the litigation. The focus in this, in any of these things needs to be on the client 100%. And I will say that every one of the lawyers, everyone, Howard Hunter from J Hatch, how many times did he make an argument that just seemed completely contrary to J Hatch's best interest?
Yeah.
Howard Hunter, Nick Whitney, Greg Anderson, y'all have lost focus here. This is not about shots against the parties. It's not about your entitlement to say your truth or speak your piece or to give answers or find these conclusions. It's not about that. This is about Maya Kowalski having a damn lawyer that's representing her to the best of their ability, and she has the choice to make. She has the right to make that choice, and you don't get to have your feelings hurt. I get it, but you're a lawyer. You don't have the luxury of feelings in these particular instances. It sucks. You take that, you bottle it up, and you move on.
What's best for Maya Kowalski is for them to work together on this case. That's what's
Yes.
best for Maya Kowalski. And if you had a fee dispute, handle it with the court. Nick Whitney could leave the firm and they could stay on this case still together as two separate firms. That would have been best for Maya Kowalski, in my opinion. But again, I don't know the inner workings. I don't want somebody to stay in a hostile work environment or have an employee they don't trust. And it's easy for me to say on the outside. Let's look at what Anderson is requesting. Deny the motion for substitution of counsel, enter an order temporarily relinquishing jurisdiction for this specific issue to be remanded temporarily to the trial court, move forward with oral arguments scheduled for February 12, 25 as scheduled, as it is in the best interest of the parties, especially the appellees, to resolve this case as expeditiously as possible. And in the event this court grants such motion with no opportunity for the undersigned to even be heard, at least require those protections required or recommended under the rules of judicial administration as to protecting the fees, requiring reimbursement of costs, and other such relief as the rules provide. So he's asking to protect his fees and costs at the very least, but he wants to deal with this issue and deny the substitution of counsel, which theoretically would mean he's still the lawyer on the case.
I don't see a world where the court does that. I don't.
Maybe because the Kowalskis don't want him to be the lawyer. Right?
Well,
that's a problem.
That's one of the problems. One of the things that you have to kind of wonder is this a shot at trying to get the Kowalskis to see this conflict and realize that for the time being, they don't have an alternative other than Anderson Glenn? Yes.
It's like one of those things you can't talk to your girlfriend, so you like put something up that you know she's going to see, right? Or like you have people that deal with no contact orders all the time, right? They find ways to communicate.
They're not supposed to, and they get into a lot of trouble for doing that. Tons of trouble for doing that, but they do oftentimes find ways. So the challenge is that you have a relationship that's clearly soured, and I don't think these pleadings did anything to help the relationship. You have first of all, the question of whether or not the Court of Appeals or the appellate court, Supreme Court or Court of Appeals, intermediate. Is it Supreme?
I'm sorry, I was reading a different document. It's Court of Appeals. Court of Appeals.
Court of Appeals. The Court of Appeals is not going to suspend oral arguments that are scheduled for February 12th based on a full briefing schedule so that two attorneys can resolve a pissing match in the trial court.
And they're not even the appellate attorneys.
Exactly. The appellate attorneys are the ones that are carrying forward this litigation. And then at the end of that, that's when the dust is going to settle. And, you don't even know if there's going to be a remand. If there's no remand, then the trial counsel is out. What are you doing? If there's a remand,
Doesn't
then we
matter.
have this debate.
Right. Well, if they win, we're going to have some discussions.
Enforcement.
My guess would be in fighting about fees and who gets what. So Greg Anderson filed a notice of attorney retaining lien on files and charging lien on judgment, award, or settlement, basically letting the court know, but also letting the defense know if you settle this case and pay some amount of money. So that is something that could happen. So whoever the lawyer is for Maya Kowalski as trial counsel is the one that would lead negotiations should J Hatch come to the table and say, we want to pay before oral arguments. You could lose the appeal, so let's come to some compromise. And whoever's advising the Kowalski could theoretically settle that case.
Correct.
So that is something big that could happen. And that does happen sometimes, which is why Greg Anderson filing this charging lien is like, hey, this case gets settled. You guys better know I'm going to get my money. And let's take a read at, and he also hired a lawyer, which is interesting. But this document is pretty interesting.
I think it's smart for lawyers to hire lawyers. I don't disparage lawyers that choose to hire counsel.
I would do the same thing.
It's the right call because the charging lien, I can see how some might say, "Oh, you're suing your client." Well, no, it's not really the case. I'm just filing a charging lien. But does Florida require you to
cases before? And other lawyers have too. Yeah. We've even told lawyers file a charging lien, right? And let's figure out what you're owed at the end. I don't want lawyers to get screwed out of fees that they rightly earned. I have no beef.
We put the statutory authority for charging liens in our fee agreements. It says that, like, look, you guys acknowledge that this happens. Sometimes when these disputes break up and you've got the issue and there's marital assets to be divided, there's a charging lien that gets lawyers paid, whether it's your lawyer, their lawyer, this ends up happening. But my question for Greg Anderson and for the Anderson Glenn charging lien is, does Florida have a rule that requires you to state the specific amount of the charging lien, what you're charging, what the amount is?
Say that. Do they have a specific amount?
Do they have a rule that says you have to state the amount, or can you say the percentage?
No.
Okay.
Yeah, you can just say, I have a lien on this file and then deal with it later. So usually what we'll ask for is we'll say, can you give us the amount of hours worked and your hourly rate? A lot of times we try to deal with this or agree to the number so we don't have to litigate it and deal with it after. But I'm 99% sure you don't have to put the exact amount in because a lot of times you don't know what the exact amount is in PI cases.
Got it.
So, all right, motion to enforce retaining lien on files and charging lien on judgment, award or settlement for fees and expenses and request for evidentiary hearing. Anderson Glenn moved to enforce the retaining lien on files and charging lien on judgment, award or settlement rendered on plaintiff's behalf for legal services rendered to, costs and out-of-pocket expenses incurred on behalf of the plaintiffs by Anderson. Here's what it says. Gregory Anderson is an attorney at law licensed to practice in the state of Florida. Mr. Anderson has been practicing law in Florida for over 40 years and has at all times been a member in good standing with the Florida Bar. Mr. Anderson's practice focuses on litigation, including personal injury law, and he is a board-certified civil trial lawyer, mostly defense. But Mr. Anderson has tried jury trials in 9 states with a total of over 100 civil jury trials. That's a lot. On or about May of 2017, plaintiffs engaged Anderson to represent plaintiffs as legal counsel for any claims plaintiffs may have against individuals or entities for injury or damages sustained by plaintiff as a result of the conduct, negligence, and or intentional actions committed by third parties responsible for plaintiff's injuries. I don't want to read all of this. Okay. Yeah. On or about May 24th, plaintiffs and Anderson executed Anderson Glenn employment contract agreement, pursuant to which plaintiffs agreed to compensate Anderson a percentage of any recovery, compromise, settlement, or judgment obtained on plaintiff's behalf, and to reimburse Anderson for any and all costs incurred on plaintiff's behalf, in addition to any attorney's fees plaintiffs might owe. When plaintiff Maya Kowalski attained the age of 18 years old, she individually executed a second employment agreement. Good, that's important. Wherein she individually agreed to compensate Anderson a percentage of any recovery, compromise, settlement, judgment obtained on their behalf, and costs incurred. Anderson, the only attorney willing to take plaintiff's case, and in reliance upon the financial terms of the agreement, including most particularly plaintiff's agreement to compensate Anderson with a percentage of any recovery, compromise, settlement, or judgment obtained by on the plaintiff's behalf, agreed to represent plaintiffs. Importantly, but for plaintiff's agreement to the financial terms of the agreements, most particularly plaintiff's agreement to compensate Anderson a percentage of any recovery, whatever. Anderson's agreement to undertake representation was a great financial risk, both personally and professionally. I agree with everything he's saying. Okay, it was a risk. She does owe him. He did work on this case. He did produce a result. He did earn a fee. And I don't think anybody on the Kowalski side would disagree with that. Acting on and pursuant to the agreements, Anderson, and he would not have done this case for free, right? We can probably all agree on that. Anderson and Mr. Anderson, in particular, diligently and successfully prosecuted plaintiff's case over 7 years, 8-week trial. Final judgment in the amount of $208,451,176 was rendered in favor of plaintiffs on January 19, 2024, and recorded in the official records of Sarasota County, Florida, instrument, whatever, which is accruing interest at the legal rate. As such, the contingency/condition of the agreement has been performed and satisfied. I agree with him. Pursuant to but it could change, right? If you get a $200 million verdict, but you settle for $100 million, then usually you'll take your fee on the $100 million. But if you're not the lawyer doing the negotiating and the settling and they settle for $100 million, you're like, well, 70 of that's mine. Pursuant to the contingency fee agreement, Anderson is entitled to compensation for legal services rendered on behalf of plaintiffs in the sum of 1/3 of $215 million, the current judgment with interest as of January 16th. Dang, that interest jumps quick. Already $6 million in interest, huh?
Yeah.
As of January 16, which equates to $70 million together with all costs and out-of-pocket expenses remaining outstanding, plus 1/3 of the interest accrued, et cetera, et cetera, et cetera, plus 1/3 of the attorney's fees. So that just means if you get attorney's fees on top, you add it to the judgment. That's the new final judgment. But one of the issues I see here is he says 1/3, which could be what they have in their contract. But the Florida standard fee agreement for contingency fee cases in Florida is 1/3 pre-suit. If you don't litigate the case, take it, to court. 40% if you do take it to court, but usually only up to the first million. Then I think it drops down to 33% or maybe even 25%, the second million. I don't know it off the top of my head, but I do know that it gets to a certain point where I think it's above 2 million, where it's only like 20%. That's kind of interesting, right?
Now, this is a question because now we're talking about things that I don't usually deal with. Is this one where the clients can deviate from the Florida standard agreement, but
Yes.
the presumption is construed against the party that drafts the agreement?
Yes, but yes, you can absolutely. I have seen firms that just do straight 40%. 40% for everything, whether it's pre-suit, whether it's 100 million, it doesn't matter. And it's up to the client.
And I imagine that there's something within that retainer agreement or within the contract that they have that allocates the discretion for accepting and negotiating settlements. Usually, isn't there something that says we have exclusive right to choose the term of settlement as long as it is above a certain dollar figure or something to that effect?
You mean the lawyer have the right to choose?
Well, it's the lawyer has authorization to accept a settlement above a certain figure. Sometimes
that's not in the standard agreements.
Not in the standard. But one of the things that you run into, or one of the things I'm looking at here is one of the things that people don't like about lawyers. There is a monetary incentive not to settle. Not to have a post-judgment settlement. And now that you have a departing lawyer who might have had, if they were still in the case, might have actually looked at this and said, we'll settle for 120 million, right? But now they're departing. So they're sitting there going, no, the judgment said 215. I expect 70.
Oh, you mean like this situation?
This situation.
Well, that's exactly what he's going to say. So are you asking me if this language is in the fee agreement?
What I'm saying is, I think this makes me uncomfortable. And I don't know how many times this comes up in litigation, but it looks like there's a massive monetary incentive to the lawyer to accept a settlement or reject the settlement, especially if they have already departed because they get a crap ton of money out of it, or they get a lot less money out of it based on what those negotiated terms are.
So let me answer this a couple different ways. Whenever I've seen a percentage that deviates from the Florida standard percentages, usually the good lawyers will have a document and explanation in there that they are deviating and why they're deviating. Because this is a difficult case, it's a risky case, it's an expensive case, and we totally understand if you don't want to hire our law firm. And my guess is if Anderson put that in here, Maya and her family still would have signed because, like I said, there were not a lot of lawyers banging down the door to take this case. Yeah. So that's number one. And I hope that he does have something like that in the contract if that's the case. Now, let me read this last sentence to kind of go for what you were talking about before. So $70 million plus 1/3 of the interest, plus 1/3 of attorney's fees recovered post-judgment. And what that means is in certain cases, if you file a proposal for settlement in Florida, or there are some statutory ways you can get attorney's fees on top. So let's say the judgment's $215 million plus the court awards $20 million in attorney's fees. You add that on top, it's $235 million now would be the total judgment and amount if the defense would pay that. He's saying I get 1/3 of all of it, not just of this judgment. And now it says the really uncomfortable part for you, Rob. Now he, Anderson Glenn, demands that plaintiffs pay the full amount of all sums due and owing, or confirm their payment upon conclusion of the case and agreement to the lien. So that was your question, and that's what I mentioned before. So it says 215. That means you owe Anderson 70 million. Well, what if they bring 100 million bucks to the table? I guarantee everybody would say yes. I shouldn't guarantee. I would be shocked if they didn't say yes to $100 million. I don't think J Hatch is paying that, but in this fake world we're talking about, this hypothetical world, if they said $100 million, the Kowalski family would probably jump at that. But guess what? Greg Anderson's like, that's fine. You take whatever you want. Out of that 100 million, you got to pay me 70. Theoretically, he can go ahead and make that claim if he wants to. But what would happen in real life is the plaintiff's attorney would go to the judge and say, we need some kind of equitable distribution here, judge. This is what's best for the client. This is what we need to figure out. And the judge would not be very happy with Anderson digging his heels in. And the judge would figure it out and he would get some percent. He wouldn't get nothing, but he definitely wouldn't get $70 million. You're not going to screw the client over to pay this lawyer $70 million if they end up settling for 100. It's also frustrating and annoying because $100 million would be a great settlement. That would be a great result. Anderson would probably, and again, I'm just guessing, would probably love to have that result and that settlement. But now that he's on the outs and he says, in light of the substitution of counsel, forget all that. I want my money and I want the full amount.
Yeah. I mean, you can't tell me that he spent $30 million in litigating this case. You can't look at me with a straight face and say that he spent that. So $100 million would be an absolute no-brainer, in my opinion.
How many $100 million settlements on individual cases do you think happens? Not a lot.
Oh my God. They get published in our bar articles, right, and it's never anywhere near that. No. We usually are talking like massive judgments are usually 5 to 10 million. That's massive judgment.
That's great. That's great for the client. And anybody that gets $100 million settlement, you'll know about it because they'll tell you if they're a lawyer. They're not going to keep that a secret. So here's what he's asking the court to do.
Wait, what's the footnote? Wait, hang on. Oh no, the footnote. Upon information and belief, plaintiffs may attempt to assert they discharge Anderson with cause. If they in fact do, the court should be aware that Anderson disputes such allegations, states further that he believes the discharge was procured by fraud and that no cause whatsoever existed for the discharge and intends to prove as much at the appropriate time.
I'm glad you pointed that out.
A footnote.
Well, that goes into he wasn't just intimating or inferring that something nefarious was going on. He just flat out said it, that he thinks Whitney and Childers committed fraud to make this substitution of counsel happen and fire Glenn for cause. But he only says it's fraud if they say he was discharged with cause. Gosh. All right. So what does he want the court to do? Enter an order determining that Anderson has a lien for services, determine the amount of that lien, meaning is it $70 million, order the proceeds be deposited in the court's register by judgment debtor, direct the clerk of court to pay to Anderson the sum found to be due for Anderson's legal services rendered and costs and out-of-pocket expenses, grant an evidentiary hearing on the matter, grant any other such further relief. It is so ugly right now. And I wanted to dig in with this into this with you because at the end of the day, Maya is the one that really gets screwed. And this is why lawyers get a bad name. And here's the point. Lawyers should get paid for their work. And if you get a $200 million verdict and your deal is 33%, give the guy $70 million. He earned it. I've got no beef with that. But to do it in this way and to say, client be damned, whatever the settlement is, I want my 70 million, that's tough. But he's not fighting with the client right now. He's fighting with Nick Whitney. And Nick Whitney's fighting with Greg Anderson. And whenever that's happening, it's a recipe for disaster for the client. And she could be here left at the end of the day with no lawyer, nobody that knows what's going on with the case, and really something that sucks as a lawyer. And we see this happening between lawyers.
Yeah. It's a whole lot that doesn't have to be said. And I mean, the court would have granted an evidentiary hearing if it came down to the fees. With all you would have had to do is write one paragraph. The parties have a dispute as to the allocation of fees. Court, please grant us an evidentiary hearing. Oh, and by the way, when you're doing that, because we're having a fee dispute that involves client communications, please seal that. And the court would have done it like that.
I would think. It's like if you
Well,
think professionalism first and client first, you do things a certain way. But when egos start to go and you start to get angry and you start to get mad and you start to feel like somebody's wronged you and is pulling one over on you, you get mad. It's one of those things like wait a night before you write the email, right? When somebody sends you a nasty email, don't just fire one back. Wait, simmer, get some time to think about it, get some counsel from other people. Like we've had some issues come up on cases where we think a lawyer has a conflict or they think we do, and there's a fee dispute. And I call all the best lawyers I know. And I'm like, hey, tell me, are we wrong? Are they wrong? What would you do? Have you ever dealt with this before? Call the ethics hotline. Sure. Call like my Florida civil practice committee that I'm on has all the legal giants in Florida, the people that literally write the rules that have been lawyers for 50 plus years. Those are the guys I'm calling. I'm like, hey, I actually had a guy that was on the committee with me, help me with the fee dispute, just his name and bring him in. The other lawyer was like, okay, he came in. We basically like quote unquote mediated it with him. It was all done. And it was just nice and easy because we were all reasonable. We came to the table. We listened to counsel. It just can get ugly so fast with lawyers because like I said, we're so confrontational. Fights can explode so quickly. And I really hate to see it. And this is a case where they were successful.
And they were so good, and they were good as a team. Like, and this is I harbor no ill will against either one of them. Like I said, I've broken bread with both of them, and I mean, I consider them both damn good lawyers. And it just it sucks because you see a situation where you can clearly see that they like one of them saw the motion or something happened. And it was seeing red. That's all they saw. They just saw red. And it just hurts. It hurts. It sucks to see something like this happen because the only person that wins in all of this is Jay Hatch.
Yeah. They seem like nice guys. They seemed to have liked each other. You don't always know what's going on the outside. And they just crushed. They got such a successful result. And it's almost like, what more do you need? It's like one of those things where success or money or whatever it is, it doesn't change you. It just shows who you really are. And it's like, was it almost worse that they did this good, that it was this big of a verdict? Did heads get too big? Did big numbers start floating around? I just don't know what happened because it really is unfortunate. And the Kowalskis are being pulled back and forth clearly. 1 minute they're signing affidavits with Anderson. The next minute they're writing emails with Whitney asking for information. It just doesn't feel good from my perspective, and I hate to see it. And I wish they would have handled it behind closed doors with email, with phone calls, with private confidential mediations. Bring somebody in. Let's deal with this together and figure out what happened. But it all broke down bad enough behind the scenes for all of this to come out publicly.
Oh, yeah. Oh, and just a reminder, this entire legal team lived under the same roof, a roof that was rented by Anderson Glenn they advanced the cost for that, but they all rented a house and they lived together while they didn't just live this case together. They physically lived together while they were trying this case.
It's a brutal one, man, but it's definitely one that we're going to have to follow. And like we said earlier on, I think Rob's going to take a look at the appellate briefs, hopefully, and be able to break those down and talk through those arguments. So go check it out. Watch, if you need any recaps or catch-ups on the Maya case, go check out Rob's channel as well. You usually because you usually do more than one case, but usually put like a picture or in the title the cases that you're talking about, right? If they're looking specifically for Maya.
There's actually a Maya playlist. I did the Maya playlist because I was doing breakdowns of that. Yeah.
Perfect. So check out his Maya playlist. Rob, thanks so much for coming on, man. This was fun.
Thank you.
Longer than usual, which I expected, but I'm really happy you came on. It's always a pleasure to hang with you for a couple hours.
It's great being here. Thanks for having me.
All right. Until next time, we're out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a pase you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the lawyer you know.